Well, generally speaking, what can happen in several different things can happen depending on your prior record, but what can happen in a lot of cases is that you'll be handed a notice of revocation of your driver's license privileges at or around the time of your arrest. And depending on the outcome of your case, the revocation period could be reduced potentially, or there are different mechanisms that the law allows that would, or the law provides for, that would allow you to drive even with a revoked license, such as an ignition interlock device program, or there are various other kinds of restricted licenses. But there is no sort of one-size-fits-all answer to that question. It depends mainly on you. Depends on what your prior record is, prior driving record is with impaired incidents. And then also what the current charges are. If it's a garden variety DWI where there had been no accident or injury or children in the vehicle, and you have taken the breath test and you are above a .08 but below a .16, generally speaking, that your revocation period would be a lot shorter than it would be as if you were doubled the limit or had children in your vehicle, if there was some other aggravating factor, if you had priors. So, but one thing that people do need to understand is that the criminal case is separate and distinct from the administrative proceeding that would result in the revocation of your driver's license. And so the judge isn't going to sentence you to having your driver's license revoked at the end of your criminal case. That would be a collateral consequence of a criminal conviction or a failure to challenge the license revocation according to law. So there is no easy answer to that question, but what I do with clients is when they come in, I try to sit down, and one of the first things I do ask them about is their prior record, and I ask them for any paperwork that they might have on the revocation issue, and then we kind of try to work that into the ultimate disposition of the criminal case.